Good morning, I'm Father X. Throughout episodes 11, we've already covered 20 best interest factors, teaching you how to testify about each one in your child custody trial. And now, we'll review our final 4 factors. The parent's observable behavior in court, lying and manipulating the court process. And many of you are here because many moms do this to you. Religion, and the guardian ad litem and forensic evaluator. These final 4 factors can make or break your child custody case, so we have to address them. Let's get to it. First, let's discuss the parent's observable behavior in court. This is the best interest factor because the judge analyzes the parent's behavior in court to learn who the parents are as people. The judge never talks to the parents outside of court, so this is how judges can evaluate parents. I'm not saying judges do a good job of this, but this is what they do. Some questions you can ask to evaluate this are, has either parent lost their temper or lost control in court? Has either parent missed court dates without notice? Does either parent ignore court proceedings as if they're above the law? Does either parent violate court orders? Regarding the first question, on parents losing their temper in court, we talked more about this in episodes 4A and 4B. If you're a dad falsely accused of domestic violence or child abuse, being angry about that is a natural emotion. If the judge gave mom temporary primary custody for no legitimate reason, and you only see your kids on alternate weekends, then being angry about that is a natural emotion. However, judges don't have any self-awareness about how their terrible decisions can make somebody angry. So instead of recognizing that, a judge is likely to assume that you're angry because you're an angry person. And they'll just assume you're not qualified to be a 50-50 or primary custodial parent, and that you're probably the one who committed domestic abuse. You have to control your temper in court. Be angry at home, privately, when you're alone. In terms of missing court dates, judges tend to assume the world revolves around their court calendar, and they find it disrespectful when you miss court dates without giving them notice ahead of time to postpone a court date. If a dad misses court dates, the judge will likely assume he's an irresponsible father who doesn't care about his child. If a woman misses court dates, the judge is more likely to be lenient. Recognize the double standard. Don't miss court dates. But if the mom frequently misses court dates, remind the judge of this in your testimony. Do that even though at the same time you expect the judge to do nothing about it. If you don't bring it up, then the judge will conveniently forget about the mom's bad behavior. Bring it up because you want to put the judge in a position where they have to address it or ignore it. If a parent is violating court orders, they look irresponsible in the eyes of the judge. Judges assume their court orders are perfectly sensible, even if a normal, competent person might see that the judge's parenting decision doesn't make sense. And judges feel that everybody must follow their court orders blindly. That's their culture. But expect a double standard for mothers. For example, if the mother isn't following court orders because she's denying you your court-ordered parenting time, your judge may or may not care. But if the mom is doing this, you can file a motion for a violation of a court order or a motion for contempt of court. You should also file a police report for custodial interference if the mother denies you your court-ordered visitation, and include that police report in your motion. Your options depend on your state's laws, so look these up. File motions every time the mother violates the order. Many judges get annoyed by motions for violation of court orders. Many don't care if the mom violates the court order. And if you show anger about the violation in court, you risk the judge getting angry at you, even though the mother is the one that violated the order. That said, file these with the police and court to force everyone to be aware of the mother's actions on the record. Just be matter of fact. Portray yourself as the victim of custodial interference, because that's what you are. Don't portray yourself as the angry father who was denied his rights. Your goal is to submit these enough times so the judge gets angry at the mother for not abiding by the court order, and the judge can see her true character. Strategically, if you don't tell the judge about the mother's court order violations, then the judge won't know and won't do anything about it. If you do tell the judge, then the judge may or may not do something about it. But you're putting the judge in a position where they must abide by the law. And if the judge chooses to ignore the law, then you can use that in your appeal, as we discussed in episodes 10A and 10B, to show the higher courts that the judge was not properly using their discretion. The second factor in this episode is lying and manipulating the court process, which frustrates those of us who care about the truth. This matters because a parent who makes false allegations to manipulate the court to gain primary custody is engaging in bad behavior that shouldn't be rewarded. Otherwise, the system becomes a system of lying, which is what it has become. A parent that makes false allegations in an effort to get primary custody and to minimize the other parent's time with the child is, first of all, not fostering a relationship between the child and the other parent, and they're not engaging in proper co-parenting, and not being a good role model on parental guidance for the child. And they're also impeding the child's emotional and psychological development by getting rid of the other parent. And also, they're probably displaying some amount of emotional and mental instability and emotional immaturity. Do you see how all these best interest factors overlap? Testify about these specific impacts on your child from the mother's lying. Assume your judge is lazy and incapable of connecting these dots. Explain it to your judge in a way they can understand. After this episode, please review episode 11D, where we discussed testifying about false allegations of domestic violence, and episode 11E, where we discussed testifying about false allegations of child abuse. Also, why would we want a child primarily raised by the parent that lies and manipulates the court? You can testify by saying, "I'm concerned about our child being raised by a parent that does these things." Use the sentence, "I'm concerned about A, B, C," because if you're concerned as a parent, then the judge should be concerned. A biased judge won't proactively think about any concerns regarding the mother. It's your job to say these concerns out loud during your testimony. That's how you corner your judge, by putting this issue on the record, where the judge has to either ignore it or say something intelligent about it. And if they ignore it, now you have an issue for the Court of Appeals. Because no Court of Appeals has ever said we should ignore concerns related to the best interests of the child. Questions you can ask to prepare your testimony around this are, has the other parent made false allegations against you in court? Don't just make broad, sweeping statements that the mother lied. Describe the allegation in detail. Describe the reality in detail. Show the contrast between the truth and the lie, step by step. What's an effective way to testify that the mother lied? In my custody trial, I testified for 28 hours, and at many points in my testimony, I highlighted how the mother lied. For example, I testified about the time the mother assaulted me in August when she was pregnant. It took maybe an hour to describe every detail of that assault, to demonstrate what actually happened that day. When I finished telling the total truth on the witness stand, then my lawyer asked me, according to the court transcripts we have from the mother's testimony on December 18, page 32, lines 10 through 20, the mother testified that on this occasion of domestic violence in August, XYZ happened. Do you recall her testimony about this? He quoted exactly what the mother said, no paraphrasing. And I responded by saying, yes, I remember her making those false statements in court. There's what the mother says, and then there's reality. And my lawyer followed up by asking me to say why her statements were false. And then I explained exactly how her statements were a lie. My lawyer and I were like a tag team with our questions and answers back and forth. And then I would proceed to testify about other topics, such as how I took care of my son, fed him, and changed his diapers. And because I was testifying in chronological order, then I testified about the time the mother assaulted me in January, 5 months after her August assault. I testified for over an hour about the exact details of that assault, blow by blow, to make the judge live in my shoes. And then my lawyer asked me, according to the transcripts from January 7, the mother testified on page 52, lines 15 through 25, saying that XYZ happened during this January incident. Do you recall her testimony? And I replied by saying, yes, I recall her making those false statements in court. There's what the mother says, and then there's reality. My lawyer asked me, why are those statements false? And then I testified, explaining why her statements about that incident were false, comparing it to my version. The key point is that you don't just declare that the mother lied, and you don't quickly state 5 different lies in one long paragraph in 1 minute as if it's a speed contest. For each one of her lies, connect it to your story, one at a time, and compare her lie to the truth, providing any supporting evidence you can. If you don't have specific evidence, then your testimony will have to suffice. Your job is to compare in detail your version of the truth versus the mother's lies so the judge can clearly understand the mother lied about this one thing. And then you repeat that process again and again for each lie. Plan your testimony ahead of time so you can organize it in a logical way for your judge to understand. Many dads worry that when the mother lies about 10 things and the father can't disprove all of them. You don't have to perfectly disprove every lie. Imagine if you can disprove 4 lies, and for another 4 lies you testify about how it doesn't make sense, even if you can't fully disprove it. And for the other 2 lies, you just say that they're lies. Well, now you have at least 4 clear occasions where she lied. And judges tend to think that if she lied about these 4 things, what else is she lying about? And they wonder if the other 6 things are lies too. And now you've begun to destroy the mother's credibility. Don't let false statements go unchallenged. If you don't testify or submit evidence that the mother lied, then everybody will assume you agree with her statements. At the very least, you have to testify that her statement was a lie. There's no guarantee of success. Your success depends on how good you are at telling your story clearly, how effective the mother is at lying, and how much of an open mind your judge has about believing a mother might actually be lying. You can't quit just because it's hard to do. You have to do the best you can to convince a gender-biased judge. The alternative is that you just lose automatically. The third factor we'll discuss is religion. I think religion used to be an important best interest factor, but it's less so now because more of the world is not religious. But if religion is an important part of your custody case, these are some questions you can ask. How does either parent's desire to raise their child in a religious environment impact this custody case? Is it important that your child be raised Christian, Jewish, Muslim, Hindu, or something else? How will your child benefit from religion? If it's important, then how will you as a parent enable this? What are the parents' differing views on religion? How does this impact parenting time? Do you need 50-50 or primary custody to raise the child in your religion? As a warning, my general sense is that the culture of family court is an atheist culture, and they don't care about religion. That's my opinion and not a scientific study. If you go into court and come across like a religious extremist, for example, if you go to court and start talking about how Jesus saves and you start quoting the Bible, the judge might look at you as if you're strange. Being a Christian, Jew, or Muslim is not extreme, but an atheist judge might think all of this is extreme because they don't believe in God at all. And you don't want to give the judge reasons to think you're a strange person who would raise the child in strange ways. It all depends on your facts and the judge's personal opinion. Whether this is right or wrong, it's something to keep in mind. There's a risk here. And the fourth factor we'll discuss is law guardians and forensic evaluators. Some child custody cases have a guardian ad litem assigned as a child's lawyer. And in some custody cases, there's a forensic psychologist that serves as the court's witness, who's paid by the parents to evaluate the parents and children. It's a psychological and parenting evaluation that reviews the family dynamics. I'll make future videos that go into these processes in more detail. However, in summary, at some point you'll have a child custody trial in front of your judge where you each present your testimony, evidence, and witnesses. But before that happens, you and the mother will be talking to the guardian ad litem or forensic psychologist. These people will write reports to the judge about their findings, and many judges decide custody based on what the guardian ad litem or forensic psychologist determines. If you win your case in the eyes of these people, then they'll take your side in front of the judge. Therefore, when you first meet these people, think about it as if you're conducting a mini trial and they are the mini judge. In your meetings with them, tell them your testimony, give them evidence, and have them talk to your witnesses. Convince them why you should be a 50-50 or primary custodial parent based on the best interest factors. Here's another tip. When you communicate with a guardian ad litem or forensic evaluator, email them immediately afterwards with a summary of your conversation, and email them any evidence that you provided to them before they write a report. This creates a documented paper trail showing that you gave evidence to these people and showing what you told them. This matters because many of these people often blindly rubber stamp the mother for custody. They do that by ignoring evidence the father gives and only listening to what the mother says, which is obviously gender biased and incompetent. If they write a report to the judge where they exclude a lot of bad facts about the mother, then in your testimony, you can testify about the evaluator's report, and you can present your email evidence showing that you gave documents and statements to these evaluators that they ignored and kept hidden from the judge. If the evaluator ignored evidence and testimony, then their conclusion must be flawed and incomplete, and you can destroy that evaluator's credibility, showing their gender bias or incompetence. Don't accuse them of gender bias or incompetence before they act this way, but take preemptive actions to protect yourself and your kids from their potential gender bias and incompetence. Just be nice about it, because you don't want them to hate you before they make up their mind. Now we've covered 24 best interest factors throughout episodes 11. Please watch episode 11H for tips on how to write, edit, and prepare your testimony. It's a lot of work to put all this information together in a clear way for your uninformed judge. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.